It says it can't start video. Is that you or me?
I think that's you. And we are live.
I'll just start the video camera pre-select.
You know how to share your screen?
I do. I was just trying to go to the, yeah, evidently my webcam's not working. It's going to go with my computer camera, I think. Yeah, it's going to go with the computer camera. Yes, I can share my screen.
Okay, while you do that, welcome everyone. And there's your screen.
Yeah.
To advanced care planning. And today we've got our speaker, Karen Telschow Johnson. And I want to tell you a little bit about Karen before we get started. She is a graduate of Texas A&M University in College Station. And she received her JD from Texas A&M University Law School as well. She speaks in front of lots of groups of all different ages and loves educating people on advanced care planning, probate, estate planning, and elder law so that families can make informed decisions and in doing so stay in control of their lives. Her focus is on finances and asset protection with an emphasis on wills, estate planning, probate, advanced care, planning matters, living wills, and elder law. And she believes that it's vitally important that families are well prepared for both the expected and unexpected events in their lives through the completion of basic documents with powers of attorneys and guardianships to more extensive preparation through tax plan, wills, and trusts. So without further ado, Karen, I'll let you take over.
Great. Thank you so much, Josh. And thank you, everyone, for having me. I know that these are not lightweight or easy discussions, but they are certainly worth having. I tell my clients all the time, the biggest thing we try to avoid when dealing with all serious matters is surprises. We don't like them, we don't want them, and it is always best to be fully informed as to what lays ahead. So advanced care planning can begin as young as 18. Some of our most complex cases in this field were the Terry Schiavo matter in Florida, right? So many years ago, and she was in her early 20s. So senior status is generally considered someone to be over the age of 65, so that whenever you hear the word senior, legally, that's the age frame that we're talking about. And so what is advanced care planning? So advanced care planning is more than just, do we pull the plug? Do we not pull the plug? All right, because everybody says the same things. You know, I don't want to be a vegetable. I don't want to be plant food. And so just pull the plug when I'm ready. But unfortunately, the body just doesn't go from being on to being off. There's a lot of levels of gradation, especially depending on what, if any, disease processes you're dealing with. So advanced care planning goes into, do you want a pillow under your head? Do you like soft things around you? Are perfumes good for you, or do you just not want any of that at all? Do you eat fresh foods? Are you a vegetarian? So, you know, so if somebody, you know, puts a nice plate of mashed potatoes and gravy and a steak in front of you, are you happy? Or are you like, yeah, no, not quite so much? And so those are things that we need to have discussions about. But the most important thing about advanced care planning is about protecting our dignity. And so we want our dignity to be retained during that time, but we also need to think about what our last best days might look like. But importantly, what laws govern this field of law in Texas? So we have documents. There are various documents in Texas that control what happens when we can no longer communicate. And then when there are no documents, there are statutes that can govern and guide us. So specifically in Texas, we have the Texas Health and Safety Code, section 313.004, that states that if you don't have a document in place that says that this is who can make decisions for me, the state of Texas has a plan for you. Typically, it's number one's a spouse. Number two is your adult children. Number three is then going to be, if the adult children disagree, it's going to be 2 out of 3, best 2 out of 3. And if it's an equal number, then we get to go to nearest living relative. And so nearest living relative is consanguinity. So, it's not consanguinity. So it's not your sister or another sibling. It could be your aunt or your uncle. So it's not consanguinity. It's those who are physically closest to you. And so like my folks are, a block and a half away from me, right? So they would be, without a document in place saying who that is, they would be the ones chosen. So, or hospitals then also have, hospitals and facilities have DNR procedures and protocols that they follow pursuant to statutes that were put in place in March of last year. But there's not a standard DNR document. So there's not a document that we can hand you in a hospital setting. And so they follow particular protocols that have to be met for DNR to be put in place. And then when people disagree, and then it ends up in a court. And that's the last place where you want your rights clarified, is with a judge that doesn't know you and family members arguing. So we want to do things to prevent that. So let's look at the statutory documents that control advanced care planning in particular. The statutory documents are the medical power of attorney. It's the appointment of a healthcare agent. So a lot of times you'll see documents that just say healthcare agent. In Texas, you'll also see the MPOA or the POAM, power of attorney for medical. There's also power of attorney for financial. And so that medical power of attorney is the document where you place in writing the people that you trust to make decisions on your behalf. The directive to physicians and or family surrogates is our living will document, for lack of a better. It's what everybody considers as the living will. It's your end of life document. And that's where you initial by your choices as to whether or not to be removed from life-sustaining treatment or to remain on life-sustaining treatment. And then the Health Insurance Portability and Accountability Act, the HIPAA document, is the one that hospital systems are most fearful of, right? So they don't want anybody receiving any medical information from you that doesn't have legal access pursuant to having be placed on a HIPAA document. And so the one I do has a 2-year post-death provision. So my HIPAA, I make sure, is good for the duration. The one that you fill out in the doctor's office is usually only effective annually. So either make sure you currently have one in effect, or make sure you have the other one filled out as well. So then the out of hospital DNR is a statutory document. It's not one you can fill out in a lawyer's office or by yourself, because it does require a physician's signature, and it's usually filled out pursuant to some disease process. So like if you have end-stage COPD, heart failure, things of that nature, you can talk to your physician about an OOH DNR. People who have been on hospice also will have that document, and they usually tape them to their doors and their refrigerators so that their wishes are enforced. And then written medical decisions. It's important for you to know that anything that you put in writing medically, you can orally change, right? So if you and your spouse, right before you go into a hospital, get in a fight, right, get into an argument, and aren't going to be agreeing with each other, you can say, hey, I don't want my spouse on this medical power of attorney. I want my daughter or my son or my next door neighbor to make my decisions for me. They will note that in your chart, and last in time wins. So let's go into a little bit of detail in these documents. This is the biggest question I get. Well, I have mom's medical power of attorney so I can make her decisions. Well, mom's right next to you and we're having a conversation. So the medical power of attorney is only effective, number one, when you cannot communicate, right? So that's kind of obvious. Number two, your communication is ineffective. And what does that mean? It means that I go to ask you a question, how are you feeling today? And you say purple, floor, ball. Well, guess what? You've had a stroke, all right? Or you have some sort of brain injury that prevents you from being able to communicate effectively. And the third time that, of course, the MPOA is effective is when you're unconscious. That's self-explanatory. All right, so when a physician is looking at what capacity is, do you have capacity at the time that they are seeing you? Let's talk about what a physician is looking for. So generally, the physician is looking for 4 abilities. These must be present for an individual to have mental capacity. They have to be able to understand what is happening around them, what is happening to them, and the information given to them about their circumstances. Number 2, they have to have the ability to retain that information. So I have, you probably saw I'm on the board of the Alzheimer's Association, and I have a number of clients and families who at the beginning of Alzheimer's or at the beginning of any brain disorder process are dealing with short-term memory losses. And I can have conversations with them, and 5 minutes later, they're asking the same questions, and we're going to have the conversation again, which is just fine, which is why we write things down a lot of times. But the ability to retain that information is definitely one of the things that a physician is looking for a capacity issue. And the ability to weigh and evaluate the information so that available to make the decision, so that they're making informed decision. Is the consent informed consent? So you have to have knowledge, you have to be informed, and physicians are clearly aware of these very legal standards. And again, you have to have the ability to communicate that decision. So when we're talking about capacity at the time of an event, these are the 4 areas that medical staff is looking at. All right, so your adult children may or may not be the best decision makers available for you. And I encourage all of my clients to take their personalities into serious consideration when deciding who should be your healthcare agents. Co-agents, so I have 3 kids, let's list all 3 kids. That is not encouraged, because if they disagree with each other, then you've got to go to court for decision-making authority. And so it's important to consider putting them alternatively. And that's always my recommendation. So like my brother is a very black and white person, right? I'm an attorney, so I see gray, right? I can see one side of an argument, I can see another side of an argument, I can take data and make a different decision. My brother is very black and white. My parents have me first and they have my brother second, and he knows that and he's fine with it because he understands his personality and what and how that might work or not work in a medical setting. He also knows that he's on my financial power of attorney, but he's nowhere near my medical. Medical is a lot of gray areas to consider when looking at all of the issues regarding hydration and feeding tubes and things of that nature. And so you might want to seriously consider the personalities that are involved when you name your agent. Importantly, do not choose anyone who would not support your wishes, who would substitute their judgment, right? Who would say, I know best, and they put me in this position because I know best, and who may not necessarily follow what you would want, and who literally cannot do that because their personality doesn't allow them to do that. So those are some factors to take into consideration, because I see that in my office many times. And I'm a big fan of having family meetings. Now family meetings consist of pulling everybody in on Zoom and on the phone, right? Thanksgiving is usually a time I encourage family meetings, but obviously this year's a little bit different. But I encourage family meetings to have this conversation so that Bill and Jane and June all know what you want. They're hearing the same information from you. And so that there's no diverse, well, mom told me this. No, well, she told me that. Well, have the conversation. And if you want to bring libation into that conversation and have a nice glass of wine or single malt with that, that can be encouraged too, if that's your druther. My grandmother, though, she would have just a nice tall Dr. Pepper. All right, so when is the Directive to Physicians and Family Surrogates, when is that document effective? The directive is effective when a physician qualifies the patient at being at the end of life, and that is written in the medical chart. We're no longer in curative mode. We're not trying to cure anything. We are at the end of life. So COVID is a good example. So one of the ways to try and treat the side effects of COVID, because right, there's no cure right now. We're on machines, and so we can't communicate. So, but we're on machines for the purposes of that machine breathing for us so that our body can heal itself, right, and get through the virus so it can survive. And so the directive to physicians is not effective just because you're on a machine. It's effective when you're on a machine and a physician qualifies in writing that you're dying. And so what does that mean? So like if you're on a machine for COVID and our oxygen sat rates are getting better, and then over a period of time, things start going in reverse, and we have kidney failure and liver failure and, blood, and we have blood pooling issues, then that means that the body is dying. It's not surviving. And so it's at that time that the physician would say, okay, now's the time for the directive to be effective. And so what does that mean? The document in and of itself classifies dying from a terminal condition differently from dying of an irreversible condition. So a terminal condition is complications from, say, cancer, all right? And an irreversible condition are complications from Parkinson's, complications from Alzheimer's. People don't die of Alzheimer's, they die of complications from Alzheimer's. And it's certainly an irreversible condition. And at some point, it could be COVID. It could also be complications from a car accident. Not all car accidents are terminal, obviously, but they can create irreversible conditions. And so that's what the document does. It delineates between those two, and then you have to initial by choices that say, I either want to remain on life-sustaining treatment or I want to be removed from treatment and kept comfortable. And so you initial by one of those two choices. Now, one of the things that's not talked about, it's about a few sentences in the directive document that people don't think about until it needs to be utilized. And that is the fact that Texas has a 10-day futility rule. You cannot stay on machines forever. That's not something that will happen in this state. It's not something that happens in most states. At some point in time, if there is distension between a physician's, the physician treating the patient and the family, and the physician states, there's nothing left we can do, we need to pull the plug, and the family states, no, we're not going to pull the plug, everything then goes to an ethics committee for review. And every single hospital, not hospital system, every single hospital from small to large, from the rural hospitals to small hospitals to THR, Baylor, Scott, and White systems, every single hospital has an ethics committee. And so this committee is then impaneled to review the medical evidence, to take testimony from the physicians, sometimes then also from the families, and then they make a decision as to whether or not the 10-day rule goes into effect. And so during that 10, and if it goes into effect, and they say you've got 10 days to either appeal our decision in court, right? So you can take it to a judge, or to move the patient to get another hospital system to accept the patient, and then the family is responsible for the costs of the move. These are very clear statutory procedures. There's no guesswork to them. The only guesswork, again, is evaluating the evidence that the committees have to do. But I think, again, I'm not a big fan of surprises. There is a 10-day futility rule in Texas. It was started actually back in the 80s when hospitals were almost having to declare bankruptcy because of NICUs and PICUs, babies who were born premature, and they needed some boundaries and some guidelines as to how to deal with those issues. And so that's when that's the origin of the 10-day futility rule, and it gets updated every couple of years, and but it's important for you to be aware of. And so I just wanted to make sure that in having this conversation that you were aware of it. All right, so what are some other documents and procedures that guide medical staff in advanced care planning? Because those are not the only ones. Texas has a medical order for scope of treatment form. It has not been stated as a statutory form only because the legislature has not given it its blessing. And so it has been brought up to the last two legislative sessions. Most states have this type of form, which I'll go into details in a little bit more shortly. And so in a lot of states, it's called the physician orders for life-sustaining treatment. So that's the POLST form. Texas calls it the MOST form, Texas Medical Order for Scope of Treatment form. The importance about this form and how it's different from the advanced care planning, the directive form in and of itself that Texas has, is the directive is only good in a hospital setting. The MOST form is a portable order. So if you go from a rehab facility to a hospital to a long-term care facility, if you're in any of these systems, that medical order goes with you. And so that's the difference. The directive, hospital setting, or it can be also in a long-term care facility setting, which under the law can be considered a hospital setting for those purposes. And so, but the medical order, the MOST form, is portable. And we're going to go into that into some detail because that's being used in all of our hospital systems now. And the first time that you see that document should not be in a hospital setting. So the next document is 5 Wishes. 5 Wishes document is effective in 44 states. It will be effective in Texas probably in the next 6 years. The upcoming legislative session, as you probably know, is going to be really budgetary focused. So despite the fact that we do have all of these things in the works and dealing with MOST and dealing with 5 Wishes, from a very pragmatic perspective, we really believe that none of that is going to come to the legislative docket. That we are dealing with such serious financial matters due to COVID that a lot of our other legislative priorities are just simply not going to make it within the 6-month time frame that the Texas legislature has to handle everything. So hold on one sec. Everybody get some water. All right, so the other procedure that guide medical staff in advanced care planning is to do not resuscitate hospital and facility protocols. Again, that's not a form. They have protocols they have to go by. So COVID's not going anyway anytime soon, but very good news on the front regarding the vaccines. And so I know that is great news in everybody's minds. And so that if we do start getting access at the end of December, we know that the earliest that we're gonna have to stop mask wearing and everything will probably be March or April. But you know, I know a lot of people like lawyers and lawyers that can do things for them, but I can't do that. But I can't sue to stop COVID, but I'd love to. Okay, so the medical order for scope of treatment. I know this is a bright pink document, but this is what the document looks like. And you can type MOST into any computer browser, the Texas MOST form, and the form will pull up. Again, it's not a statutory form, but it is one that will be handed to you in the hospital. And I knew about the MOST form, because, to be honest with you, because I knew about it because this is my field of law, right? So I've known about it for a number of years. But it hit home for me the importance of this document. I had gallbladder surgery last year, right? And it wasn't an emergency. It was getting pretty bad. And so I was able to schedule it. So the last time you want to have surgery is when it's an emergency because you don't know who's going to be doing the surgery. So I got to pick my surgeon and pick the time and got that done. And I'm on the gurney about 10 minutes from going into the surgical suite. And they say, okay, so here's the Texas MOST form. We want you to fill this out. Really? 10 minutes from my surgical time. And you want me to go through this very involved document telling you whether or not I want CPR, whether or not I want certain kinds of treatment, and you're about to roll me in. And by the way, it's a gallbladder. It's not any big thing, right? It's not cancer. It's not a heart attack. So I decided it's a pretty routine surgery, and we're talking about this form anyway. So that's the first time I realized it's being used widespread in THR and Baylor systems. And so that it's important for you to be aware as to what it is. The Mohs form is a portable order. It does need to be signed by a physician and of course yourself and your designated surrogate. And it contains the following. So there's 4 sections to it. All right. Section A is specifically about CPR. Do you want them to attempt resuscitation, including mechanical ventilation, say that 10 times fast, defibrillation, and cardioversion? It requires choosing that you want full treatments, you want everything done, or you don't want them to attempt CPR. And so in section A, you have to choose one or the other. Now, I will tell you that there are, when I'm in my 50s and I'm 54, 55 next, double nickel next year. In my 50s, I'm in pretty good shape. I exercise regularly, do everything, okay? But if I get to my 80s, my 90s, if I'm 120 and I'm having issues, yeah, pretty much keep CPR off the list. The survival rate of CPR is about 5% in a hospital setting, and it's about 2% out of a hospital setting. And so it's not a very good survival rate, unlike on Grey's Anatomy. It's just simply not the survival rate that you see on Grey's Anatomy. So there's a real kind of cognitive dissonance in understanding the side effects of CPR. So if that's something that you would want to talk about with your physician, I highly encourage you to do so if that's something that you're concerned about. So then section 2, okay, so it goes A, B, C, D. So section B is initial treatment orders. And so do you want full treatments? Full treatments is CPR, do everything you can. Do you want selective treatments where the goal is to attempt to restore function while avoiding intensive care and resuscitation efforts, the ventilator, the cardioversion? May use non-invasive airway pressure, antibiotics, IV fluids is indicated, but it avoids the intensive care unit and a transfer to a hospital if treatment needs cannot be met, say at a current location like, a nursing home or at-home care. So full treatments, selective treatments is one, and then the third is comfort-focused treatments, and you have to pick one of these 3. Comfort-focused treatments is the goal is to maximize comfort through symptom management, allow a natural death. If I'm in my 80s, 90s, let's say 90s, because, allow a natural death. They can use oxygen, but they're not gonna, manual treatments. They're gonna avoid treatments like CPR. They're gonna avoid respirator. They're gonna, being on a breathing machine. But, BiPAP, when they just put it over your nose and whatever, that's still gonna be allowed in a comfort-focused treatment. Transfer then to a hospital only if comfort cannot be achieved in a current setting. And so in that second section of the document, you pick one of those 3. C, you have additional orders of or instructions. So if you have an issue regarding blood products or whether or not you want to be on or off dialysis. So other protocols for your specific health needs, this is where you would put those additional orders. And then D, the last section, is medically assisted nutrition. And so do you want only food by mouth? Do you want to provide feeding through a new or existing surgically placed tube? So maybe, nasal gastric, yes, but a PEG tube, no. All right. So these are all things that remain within your decision-making authority, or you don't want artificial means of hydration, or discussed, but no decision is made at that time. You can say that as well. And so then you have to sign it, your representative can sign it, and then your healthcare provider can sign it. And then this medical order is portable. It travels with you. And again, if you want to change it at any time, you can change it. And so again, the most important thing about this document is it is in our hospital systems, and I hate for people to be surprised. So I hope that you have found going through that document helpful. So the 5 wishes document, is effective in 44 states. And so wish number 1 is currently who is your healthcare agent. Texas has a statutory form for that. So for wish number 1 on mine, I just cross it out. Wish number 2, the kind of medical treatment you want or you don't want. Wish number 3, how comfortable do you want to be? So I'll give an example of that. So there are people that can't take pain. They don't want any kind of pain. They'd rather be drowsy and kind of out of it than have any kind of pain. Then there's people like me. I will tolerate pain if I can still communicate with you. You probably guessed at this point that I like to talk. And so, and that's important for me. It's really important for me to be able to communicate. So when I think about what do my last best days look like, what do I want to be able to do? And if I can't do that anymore, I'm done, is I need to be able to communicate. I need to either be able to write, which means typing on a computer nowadays, because who writes anything? Or I need to be able to talk. And so that's important. I'll take a little bit of pain. I'll take dealing with pain for that. But my mother, she knows this and I know this, and we're very clear on this. Any kind of pain level, she can't tolerate that at all. She would rather have a lot of medication. How do you want people to treat you? Do you want a lot of friends and family around? Do you not want people around? Do you just want to call once a day? If you can't communicate anymore, you need to make sure your family knows how you want to be treated. And they're not going to know that without your having the conversation. So wish 5, what I want my loved ones to know. So the last portion of the document contains a section for signing the document and having it witnessed. Again, in Texas, it's not a validly legal document. You can sign it, but it doesn't have to be witnessed. And why is 5 wishes important if it's not a valid legal document in Texas? Because the more information your care providers have for you, the better. And the more information allows them to provide you what you need when you can't communicate for yourself. And there is no greater gift that you can give your family than that. And so, so I have attached, so in the directed to physicians in Texas, there's a section that says additional notes. My additional note says see attached document. And in the attached document is 5 wishes. Wish number 5 also goes into your funeral wishes. And so whether or not you want to be cremated or buried, if you have that done in advance, that is also a wonderful gift for your loved ones. And so, and I even put down, you'll appreciate this. So I put down a song, but I couldn't remember the exact name of the song. But one morning last year, I told my son, okay, I've got everything done. You know, I know what kind of funeral I want to have. I've written everything down and it's in my 5 wishes documents attached. And my kids know where all my documents are. And my 17-year-old looked at me and said, I'm going to call fake news. You do not have that song written down. I don't believe you. And I'm like, really? Because, you know, lawyer, and I don't lie to my kids. You know, holidays, gifts exchange, things like that. But no, I didn't buy that. Anyway, and he said, well, let me see the document. So I always carry it in my purse. So purse, you know, if you have a purse, put it in your purse. Also put it in your nightstand and put it in your glove box of your vehicle. Everybody has a nightstand. Everybody has a vehicle nearby them. And so that's where you put all of your medical documents, your powers of attorney, your medical power of attorney, and your directive, and 5 wishes in a most form if you have it. And the reason for that is it's easily accessible. When you're having a medical crisis, you're not going to think about, oh, what file drawer is that in? Where did I put that? No, nightstand, glove box. If you want to have it in your purse, I have mine in my purse. But other people also consider putting it on the refrigerator. Just sticking it up on the refrigerator so it's easy access. It has to be easily accessible. And then also, every single time you walk into a physician's office, hand it to them. They're going to scan it in and they're going to hand it back to you. It'll become a part of your electronic medical record. And so, so that'll be easily accessible to them. So anyway, as far as the song goes, I had written down 525,600 minutes. I love that song. It's a great song, beautiful. And he says, oh, it's fake news because it was the wrong title. So the title is Seasons of Love. So I love that song. And, and everybody can have a good cry and then they can, go dance and eat a lot of food. So lots of food. That's just, you have to have that. All right, so important, what you can and can't do. Express your wishes in writing. Tattoos are not necessary. There have been at least 3 lawsuits in this state on this particular issue. 2 out of 3 eventually stated the tattoos are okay. But the one that kind of made it up to the appeals process, because, time is a factor when you're dealing with these issues, right? So we don't have time to really get too far in court. Said that the tattoo really wasn't binding, and they were able to find a directive document. But you don't need to do that. You really don't. All right. So what does the future look like? What are we looking at next? What's down the road? Hold on a second. I think my mouse gave up. Nope, there it is. The most will be a statutory form. 5 wishes will be officially, 5 wishes is currently officially recognized as part of the MPOA or directed to physicians. The Texas Medical Association recognizes 5 wishes because they're one of the biggest people who were pushing for it to be recognized as a part of the MPOA and the directive. It's the Texas Hospital Association, THA, that is still having issues as they concern themselves with liability. And so we'll bridge that gap eventually. And so this is our idea, right? To die young as late as possible. That's what we all hope for. But when that doesn't happen, it's important that you have your wishes in writing. And I hope I made clear to you the importance of doing so. I'll be happy to help, but you're in great hands with Josh, because I know he's a big proponent of making sure these documents are done and that your financials are in order so that you can live the life that you want. And but if you need to contact me, there's also my information, and I'm right here near the corner of 20 and Hewlin, and right kind of behind La Madeleine and Home Depot in a 6-story office building. And I've been doing this for a number of years now, and I really love what I do, in case you haven't guessed by my passion for it. But I'll be happy to answer any questions.
Karen, thank you so much. I've got a question, and folks, I forgot to mention this at the beginning, but there's a chat feature on Zoom, and you can probably find that easily on your bar somewhere. So if you have questions, please just type those in the chat feature. And but I have a question while we wait, Karen. You talked about keeping documents in your glove department, in your purse. One of the things that I've always recommended is people to scan them in and then to keep them on their phone. And so
Yes,
I have like a Google Drive that I can access on my phone. And so all of my important documents I keep on there. And of course, it's password protected. And so my question is, do you see any problem with that? And I guess my thought is this too, is if I went to the doctor and they wanted a copy of it, I could just simply email it to them very, very easily. So I'd have it right there in my hand, ready to go. I can also share it with my wife, which is what I've done. So she also has access to that shared drive, so she can pull it up on her phone. And then I can share it with whoever else that I want to share it with, my kids as well. And so my question to you is, do you see any issues with that where an institution would have a problem with taking a digital document versus me having to carry the paper document?
No, I don't think there is an issue with that. I think that is the better standard of practice, right? Because if it's on your phone, it's obviously readily accessible. My kids have my documents on their phones as well. A lot of people are using Google Drive, shared drives to do that. And they copies of these documents are as effective as originals. Now, financial documents is different. The financial power of attorney, banks typically want originals. The court wants an original will, but medical documents, copies are just fine. And just being able to email it to somebody right there from your phone, I think that's very convenient, Josh. Very convenient. No legal issue with that.
Okay, great.
Yeah.
And I don't see any questions coming in. If you have a question, type now. We're running out of time. So we will replay this. We'll send this out as a replay to all of you folks. So I know Karen covered a lot of information today. And so we'll send that out as a replay. And then we may post it on Facebook. Karen, you okay with us posting this on Facebook?
Yeah, that's fine.
Okay, perfect. So, well, I don't see any questions coming
Okay.
in, but if they need you, they can reach out to you. And actually, let's see.
Oh,
Maybe-
Richard,
Yeah.
I see one from Richard. Where do you get the 5 wishes document? If you, again, if you type that into Google, it'll come up. It's done, a nonprofit agency out of Florida started this process a number of years ago, actually with Mother Teresa, who wanted something like this. And so it was kind of a team effort for a lot of people a number of years ago. And so it'll be there on, if you just type it in, it'll be up on Google, but I can certainly also send Josh the link to get out to everybody
Okay.
as well. And then I can send the link for the Texas Most form too. Yeah, we can do that. Yeah, I was just looking that up real quick. Aging with Dignity. That's the name of the organization that puts out that document.
Great. Okay. Well, hey, Karen, thank you so much. And to all of you listening today, thanks for attending. And I hope everybody has a safe and wonderful Thanksgiving. We'll
Happy
see you
Thanksgiving, everyone.
then. Thanks, Karen.
All right, take care.
Bye-bye.
Bye.